Supreme Court is set to hear oral arguments today in the case of a woman who alleges she was discriminated against at work because she's straight. Marlene Ames says she was passed over for promotion, even demoted, in favor of two gay co-workers that she says were less qualified than she was. Ames filed a discrimination suit against the Ohio Department of Youth Services, but it was dismissed by a lower court. Now the Supreme Court has agreed to debate the case and whether or not she can sue. I want to now bring in Jesse Weber, attorney and host and NewsNation legal contributor. Jesse, always good to have you. You know, I was thinking we usually see the opposite here, right? Discrimination lawsuits for a minority. But as a heterosexual, she's the majority here. So what kind of case do you think she has?
Yep, it's called a reverse discrimination case for a reason. It's not the first reverse discrimination case we've seen, but what makes this so unique and why it's so important the Supreme Court is seeing this is because the Supreme Court will determine whether or not a majority group who's claiming discrimination, whether or not they have to meet that extra step, that extra hurdle. We call it background circumstances. Basically, if you are in a majority group and you're claiming you're discriminated against, you would have to show, a lot of circuits say, it's not uniform across the country, but a lot of circuits say, you have to show background circumstances. In other words, a pattern of discrimination, more concrete evidence that you were discriminated against. That's how you get into court. Doesn't mean that she would automatically win her case. It still would have to go to trial. But can you reach that extra level to get into court? Yeah. And the counter argument to that would be discrimination is discrimination. It shouldn't matter whether you're a majority group or a minority group. But what I will tell you is this is a big decision from the Supreme Court, because if they decide to go away with that standard, there, of course, it would make it much more easy for those in majority groups, those who are white, those who are heterosexual, who are fired or have some adverse employment decision, who will claim that they were discriminated against because of protected class. So you might see more lawsuits come forward if the Supreme Court sides with the plaintiff here.
And when you talk about her needing to provide, more or a pattern, I know the Republican AG of Ohio is saying she simply doesn't have the evidence to support her claims that her workplace is quote, that unusual employer who discriminates against the majority. What exactly, just break that down for us in layman's terms. I mean, what is that evidence going to have to look like for her? Is that emails? What would that look like for her to prove?
Sure. It would be any kind of evidence like that if there was another employee who she believes was discriminated against based on those same categories or those same characteristics. I'll tell you, one of the challenges here, Markie, is that her supervisor was straight. And obviously that's going to be a problem, right? But if she claims, look, I was demoted and my old job was taken away by gay and lesbian individuals, that's on its face is an issue. Or if she can just demonstrate that there was some sort of communication that she wasn't in line with a more a certain proactive stance that they were taking, maybe that would help. But again, this is just for her to get into court. It still would be a challenge if she can prove it in a court of law at a trial.
And given just the conservative makeup of the Supreme Court right now, where do you think they're going to land on this one?
Well, look, the Supreme Court has trended more towards the idea discrimination is discrimination. I think it was, in 2023, Chief Justice Roberts said racial discrimination, in order to end it, eliminating it means eliminating all of it. We know that the Harvard and UNC affirmative action cases that the Supreme Court decided, they basically said that there are very limited circumstances where racial preferences are okay and that you need equal protection for all. So if you are going to make a case like this, that you shouldn't have such an exacting standard for a majority group, this is the court that you would want it to hear it, and this is the time you would want to hear it. And by the way, with so many, a war on President Trump's administration on DEI programs, if this is successful for Ms. Ames, the plaintiff, you could see more people saying, I was discriminated against because of diversity, equity, inclusion programs.
An influx of these reverse discrimination cases could come through. We'll be watching closely. Jesse Weber, I got to end it there, but thanks so much as always. Yeah. Appreciate it. Thanks for watching, everybody. Go to joinnn.com to find NewsNation on your television provider. Also, don't forget to click that red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.